I thought this was a complainant who just needed a place to stay with her children. That's the way the testimony was given to me, that they were not your biological children.
It's the mother of my children.
Okay.
We've been together for it would have been 5 years last year in November.
All right, so that means that she should have been under the housing then.
She wasn't under the housing, when she made the statement calling, and she wasn't there for the first 2 months that I was supposed to get a 2-bedroom, 2-bath, was because I found a week before I got housing, I found out my baby mama was cheating on me.
You mean the mother of your children?
Mother of my children. She was cheating on me.
All right, court is calling 2024 CR 012731 State versus Cody Lane Cross. Could I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Defense?
Morning, Judge Mark Garland for the defendant, Cody Kraus.
And are you Cody Kraus?
Yes, ma'am.
All right, you entered a plea of no contest to count 4 on February 3rd. The state waived counts 1, 2, and 3 without objection. And defense counsel waived a PSI. Is that correct, defense?
Yes, Your Honor.
All right, so we're here for sentencing. According to your plea bargain agreement, the state is proceeding on count 4 only. They're asking that your punishment be assessed at a cap of 6 years in the prison. There's a $1,500 fine. The state will make no recommendation to your application for community supervision. And the state opposes your application for deferred adjudication. This is run concurrent with 2024 CC 742862. State is taking in consideration 2024 CC 742860 and 2024 AL 004803. And there's to be no contact with the complainant. Defense, do you have any witnesses?
I don't, Your Honor, but an issue that arose at the last date that the court was ready to sentence Mr. Kraus was you had asked me to contact the Durant County, Oklahoma clerk for purposes of trying to find out what was going on up there, and I have some information for the court.
Oh, yes.
So, Your Honor, he's got a one.
And here it begins. Cody Kraus stands before the court once more, burdened by past charges, probation breaches, and a troubled family life. But will his plea deal be enough to spare him, or is prison inevitable?
Case number with 2 misdemeanor charges in Durant County, Oklahoma. The pending charges up there are driving under the influence of dangerous drugs and possession of dangerous drugs. So again, apparently the way they do it up there is 1 case number, but 2 counts, so to speak. So going further in my conversation with the clerk, again, I know this is hearsay, but having heard no objection, I wanted to tell you that what the clerk represents is that, like Texas, she doesn't know if they're going to place a hold on him here and come and get him within 10 days. So I can't make any representations to the court in that regard. If they, just based on my experience for misdemeanors, generally speaking, I'd find it unusual for one state to go pick up another. But again, that's kind of anecdotal, and I know you know as well as anyone what the likelihood of that is. But in any case, Judge, we're asking that the court grant Mr. Kraus deferred adjudication. And I know that probation has also been applied for and that the state is neutral on our application for probation, but it's our position that if you give him regular probation, then he'll be somewhat hamstrung in terms of his ability to obtain gainful employment because he'll have a felony conviction. So with all due respect, we'd ask that if he has a chance at some sort of community supervision, that it be deferred so he's not addled with the felony conviction if he goes forth and tries to succeed. And just as a reminder for the court, we had a witness named Ms. Regalado, who's here again today, that testified about his time in the foster care system and stuff like that. So he's had a rough go of it. And then finally, I'd ask the court to take notice that his actions have not been without consequence. He's done a lot of days in jail. And so again, we're asking the court to grant him deferred adjudication at this time.
All right, and the court remembers the previous testimony, and correct me if I'm wrong, if my memory is wrong, but I believe the witness testified that the complainant was not supposed to be on the housing. It was just the defendant, and the defendant allowed or requested that the complainant be under his housing so that she and her children would have a place to stay. Is that correct?
Notice what the defense is attempting here. They're framing the Oklahoma charges as mere misdemeanors, but judges treat out-of-state charges seriously since they reveal a pattern. And in sentencing...
Maybe misremembering, but I think it's something along those lines, Mr.
All right. All right, state you're opposed.
Yes. The previously stated at the last hearing, his criminal history that he has, is the new charges up in Oklahoma. We feel that deferred adjudication would be inappropriate for this case. We are silent though as to his application for police increase.
All right, so this is what the court is wrestling with. But for the fact that this was his housing and the complainant technically was not supposed to be living under his housing voucher, but he took her in because she had children. If that issue wasn't there, you'd be going to prison. It would not be any type of constraint for me as far as sending you to prison. But I have to sort of weigh that. But then on the other hand, I'm weighing it with what I'm reading in the police report. That's an issue for me. Because what I'm reading in the police report is she called saying that you were in violation of your bond and were attempting to break down her door, which is your residence, and that you were just placed in jail for the same thing, and you had the no contact order in place, but you still went over there. So I don't know if you want to address that. And you're telling the officers it's just a misdemeanor. So do you want to address that for the court? I mean, if you don't have to. I mean, you waived your right to remain silent by entering into this plea. But if you don't want to address it, you don't have to. But that's my concern. My concern is that you knew you were not supposed to be there. You were just released from jail. And it states, upon my arrival, and this is the police, I identified suspect 1 by asking his name, to which matched the key card, and I placed suspect in handcuffs. Suspect stated he just got out of jail at approximately 1 a.m. and arrived at the location on bus because he just wanted a place to sleep. Suspect stated that the listed location was his home and that he did not know he had a protective order. Suspect, however, contradicted himself by stating he made contact with the witness 1, that's Jasmine, through the phone, asking witness 1 to leave. I explained to suspect that he was not allowed to have any contact with witness 1. Suspect stated he did know he had no contact order with witness 1 while in the back seat of my patrol car. They patted you down for weapons, and while in the back of the patrol car, I gave commands for suspect to move his feet inside the patrol car, which suspect became non-compliant. I informed suspect it would be in his best interest to comply, so he would not catch an additional charge for resisting arrest, search, and transportation. Suspect stated it's just a misdemeanor. And then you proceeded to kick the car door.
Door right there. Did you catch that? Judge Boyd essentially says, if not for one small technicality, I'd have no issue sending you straight to prison. Viewers, what do you think? Should compassion...
And then the other problem is, witness stated officers were at the listed location earlier this morning. Witness stated that during that incident, she reported the suspect calling her, threatening to harm her, and suspect stated he was going to show up to the above listed residence. And so there's a police report for that. And then it says you showed up at the above listed residence at approximately 5:55 hours by transportation of the via bus to the residence. Witness then stated, prior to Officer Watts and my arrival, suspect was attempting to enter the residence by kicking the door with his foot and hitting the door with a rock. I observed what were shoe marks located on the door near the lower side of the door handle. Witness also stated suspect threw a rock at the door and attempted to throw it at the apartment balcony door, where I observed the rock located on the apartment balcony. So, do you want to say anything?
Your Honor,
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
so,
All right, and then it says, suspect stated that when he showed up to the residence, he was going to kick witness 2, Christopher Nunn, in the head and stomp on his chest. Suspect then made threats to witness 3, Dylan Moore, stating he was going to catch him and beat him up. All right, what would you like to say?
so with that being said, I know what the paperwork says, Your Honor, and, please.
I'm sorry, you need to speak up. I can't hear you.
I know what the paperwork said, and I understand that's, that was who I am, who I was. And these last 5.5 months that I've been incarcerated,